Hi, welcome to Chapter 5, one of my very favorite chapters in regards to negligence. I'm going to be going over a very brief overview of what negligence is, and then the rest of the information we'll probably be discussing in class. So let's take a little closer look of one of my favorite topics in law. So, hotels and restaurants are not the insurers of guest safety. Tort, many types of non-criminal wrongs done by one person that injure another. Tort is what we're really trying to get at here. It's basically where there's an injury that may occur and the person has some damages. When the person does not act like an appropriate, reasonable person, that is where negligence usually occurs. You could also argue that they are somewhat careless or they're not as responsible as they were supposed to be in the first place. So the elements of a negligence case is that you have a legal duty by the defendant. The defendant is the person that you are probably suing, and you are considered the plaintiff, that you are the one that is suing that person. What you're arguing is that there is a breach of that duty. That means the defendant was supposed to do something. There's been an injury to yourself, and whatever they did is the proximate cause of your injury. Now, we do not owe everyone the duty to act reasonably. We owe specific duties to act reasonably, usually in the business of hospitality, law, and tourism, and that's where negligence usually occurs in that field. So, breach of duty, defendant must not only owe a duty to the plaintiff, but they must act reasonably. Reasonably is the key word. Reasonably has to be proved in a court. And that reasonably term is what is very challenging, very difficult in the courtroom. And they must have breached that duty. So not only do they owe the duty, but they have breached it, meaning they did not fulfill it. So let's go on what a reasonable person is. A reasonable person does not have bad days, is always up to standard, and they always act of a reasonable behavior. Refers to the direct and immediate cause, meaning whatever they chose not to be reasonable about, that was what caused the injury. And when it's reference to a pre-existing condition, a physical impairment suffered prior to the fall, that basically means that if the plaintiff had an impairment that caused them to be injured, then it really wasn't the defendant's fault. So let's move on, since we'll be discussing a lot of this in class, and again, we'll probably spend a lot of ample time on this. So the legal status of a plaintiff. A duty of care owed by a hotel or a restaurant for the safety of the person that's visiting their hotel, whether they're eating something there, sleeping something there, swimming, etc. Duty owed to invitees. An invitee is someone that's been invited to the business when they are an open business. And what they owe to that invitee is that there are no dangerous conditions, and they did things to evaluate the property, that there is no existing dangers that they are aware of. And if there was, they need to fix it, or they did fix it. So liability may result if the business knows about the dangerous condition and doesn't do anything about it. Should expect that invitees, the people visiting their hotel or restaurant, will not discover or realize the danger. They should expect them not to realize that it exists, and that fails to exercise reasonable care to protect these people against the danger. Necessary reasonable care encompasses both repair of and warning about the dangerous condition. So if there is like thin ice, there should be a sign that says thin ice. Or if the floor is wet, it should say careful wet floor. So as you can see, there is very, very much. A trespasser is something we'll go in a little bit more. There is a duty for trespassers, but that duty is a lot less compared to invitees. Let's move on. So as you can see, negligence doctrines generally favor the plaintiff, which can be really scary if the hotel or the restaurant are the defendant. Children in the reasonable person test. This is important as well. Children do not comprehend the dangers to a mature person, obviously, because they are children. They can't really weigh the cause and effect accurately. They're not expected to recognize risk, and it's a duty of the adults to act reasonably. This is very important, especially when there is going to be children in your facility. Room furnishings. A hotel must anticipate dangers and use reasonable care to protect against them when furnishing a room that will be occupied by children. So also keep that in mind. You have to look into the room, make sure that everything around there is in safe condition for children. Attractive nuisance doctrine, which was one of my favorite doctrines, and I'm positive you'll be tested on it. A landowner generally owes no duty to a trespasser. However, there is one exception to the rule. That is child trespassers, called the attractive nuisance doctrine. Basically, if a nuisance, and an attractive nuisance could be something as simple as a pond, is very enticing to the child, then the hotel and the restaurant should be aware that such an item would be very attractive to the child, and they have to take precautionary measures. Example, a swimming pool, large empty box, snow pile, etc. And so what are the elements of this doctrine? A condition exists that is attractive to children and is likely to cause them injury. The owner or occupier of the land knows or should know of the danger, and due to the children's immaturity, he does not appreciate the danger. So, this is very, very important. Always keep in mind of that. So we are going to be basically going over the other items in class. And I just wanted to give you a very brief overview of the most important parts of chapter number 5. I look forward to seeing you in class. Have a good day.